Hello there, Andrew Bethel with the Bethel Law Corporation, and today we're going to be discussing property tax reassessments on transfers of property through the medium of a trust. And we're primarily focused on transfers between parents and children. Now, for some context, every time a property is transferred, it is subject to a reassessment for property taxes, but there are certain situations where a property can be excluded from that reassessment. Now, the most common, or the ones we're really concerned today about, is the transfer to a trust and also a transfer between parents and children. Now, we have done videos on these types of transfers in detail, so if you want to learn more about that, you can watch our video on Proposition 19 here in California. But today we're worried about the transfer from parent to child, usually as an inheritance through a trust. So rather than just throw a bunch of legal codes and laws at you and just kind of sort things out from there, we figured it would be best to actually look at a real-world example. So today we're going to be looking at some recent, albeit from 2021, case law directly on the matter. And here we have Bonnet v. County of Santa Barbara. Now, that case went all the way up to the California Court of Appeals. And the California Court of Appeals found that in this instance, when a son purchased a property from his parents' trust after they passed away, he actually is subject to a reassessment on that transfer from the trust to him because his siblings all had a beneficial interest in the property. So we'll get into how we got to that right now. So for some context as to how we got there, the facts of the case are that mom and dad set up a trust, and in that trust they put a rental property in there. Now, after mom and dad passed away, that trust became irrevocable, meaning it can no longer be changed, and their children became the beneficiaries. They happen to have 13 children in this situation. So following that trust becoming irrevocable, following mom and dad's death, a form was filed with the county assessor, what's known as a parent-to-child tax reassessment exclusion form. And what that does is it tells the county that there's been a transfer of a property from a parent to child, or could be the other way around. But here it was parent to child, and that thus that transfer is excluded from reassessment. So it just tells the county, don't reassess the property. Now, that property remained in trusts, collecting rental income and distributing out to the 13 children for another year before one of the sons decided to purchase the property. He bought out his siblings, essentially. So he delivers the money to the trust disperses the sales proceeds to all the beneficiaries, meaning he probably got a little bit back to himself. And then the property was then distributed to him. So he takes on the property, and in that transfer, he also files that parent-child exclusion form, saying, well, I'm a child of mom and dad, this was their property, and therefore they transferred the property to me, don't reassess it for property taxes. Well, since we're here, you can probably figure out the county did reassess the property for property taxes. And as I mentioned, it went all the way up to the California Court of Appeals, and he lost at each road on the way. Now, before we get into the court's rationale here, I do want to kind of touch on how some background context that you'll need. Now, when putting a property into a trust, you might think, well, the trust now owns the property, which is true in a sense, but there's a little bit more to it. A trust holds the legal title to that property, but the beneficiary of that trust has a beneficial interest in that property. So how that works in practicality is that mom and dad transferred their property to the trust. The trust legally owns that property, has legal title to the property, and when mom and dad passed away, the children are the beneficiaries of that trust, and they have a beneficial interest in that property. It's actually how they have standing to be able to sue if they think the successor trustee is mismanaging. That's their standing to get into court. Now, in this case, that interest was actually kind of used against this brother. So again, All the siblings had a beneficial interest in the property, although the trust had a legal interest in the property. And we'll discuss kind of the differences and how that plays out more in a subsequent video, but for here we wanted to just look at this particular case. So again, the trust owned the property, the brother purchased the property from the trust, so all the siblings got their distribution from the trust, but as liquid assets, so cash, and the brother got the property. Now, because those siblings had that beneficial interest, even though they didn't have the legal interest, the county felt that that beneficial interest was then transferred to that purchasing son, and thus there was a sibling-to-sibling transfer there. And because it was a sibling-to-sibling transfer, they can reassess the property for property taxes, because a sibling-to-sibling transfer is not an exempt transaction like a parent-to-child transfer is. So that son took it all the way up to the California Court of Appeals, which is not cheap, meaning that probably means the property was probably worth a lot of money, meaning it was worth the time and effort to put into fighting that reassessment. Now, there's a couple ways to solve this problem. The best way to do it is to solve it at the parent level. So when writing one's distribution for their trust, you can set specific gift distributions of your assets. So for instance, if the son wanted that property and mom and dad knew it, mom and dad could have directed in their trust to say, son gets this property and all my other children, they get liquid assets. They could even say, everyone gets everything equally, but my son's distribution is specifically supposed to be made up of that property. The other way to kind of manage the situation is if there were not enough money, if there wasn't enough funds in the trust in order to have that kind of split, which is probably what happened here, the parents could have purchased, for instance, a life insurance policy and make the trust the beneficiary. That would give the trust some instant liquidity that they can use to distribute to the other siblings, and then that son could receive the property and everybody gets the same value distribution at the end and no tax reassessment because the son is designated to get that property. Other ways involve kind of what happened here where the son tries to purchase the property, but there's a lot more considerations that need to be done before kind of going headlong into just kind of throwing some money at the trust. So if you are in a situation where you're looking to be the beneficiary of a trust, but you want to do a little bit of a different distribution than equal to everybody, or you want your distribution to be made up of a particular asset, namely real property, and the other beneficiaries are fine with just taking liquid assets, before anybody does anything, you should really speak to an attorney in the area to make sure you have the steps done correctly so as not to trigger a tax reassessment and be in the boat that the son here found himself in, where now he has this big rental property with this sudden increase in the property taxes, which is going to eat up a lot of those rents he's going to end up receiving from the rental property, and now all his siblings just get the value of it in cash and they don't have to worry about taxes at that point. So again, if you're in that situation, speak to an attorney before making any deposits or loans or purchases from the trust, but it can be solved at the parent level, but it needs to be solved at that point while those people are alive. After they pass away, there's a lot more maneuvering that needs to be done. Thank you for watching. Be sure to like, comment, and subscribe, and ring the little bell to stay up to date. Otherwise, we'll see you again soon.